This is Lin Li. So before we get into your questions, let's briefly recap on what issues you're facing. So first of all, I understand that you have purchased a registered freehold property from Charles. So after you took possession, you found out that another person was occupying the land whose name is Tina, and she claimed that she has a lease agreement with Charles and that she has been living there for like 2 years and she has another 5 more years to go. So the next issue is that Charles' brother, David, has also come forward claiming that he has an option to purchase the property which he had entered into with Charles 3 years ago. So now, after the brief recap of the issues that you're facing, we can now focus on the questions that you have asked. So the first question is, does the Land Registration Act 2002 offer adequate protection for you as a registered proprietor? And what kinds of interests might override your rights? To answer your question, yes, the LRA 2002 does offer adequate protection for you according to Section 29 of the LRA 2002. So in Section 29, it states that if someone buys a registered property and registers their ownership at the land register, their ownership takes priority over any earlier claims on the property that were not properly registered or protected. So when applying this to your situation, your ownership is prioritized over any earlier claims that were not registered. There exist 3 principles that could help you that provides you protection. So the first one is the mirror principle. It refers to the idea that the due registration of a land title must reflect all the important and significant details that a purchaser must know before buying the land. So in simple terms, it means that all the facts that are relevant to the title of the land are to be found on the register. So according to Gray and Gray 2008, which is an academic article about land law written by Susan Gray and Kevin Gray, the objective of land registration is that any prospective purchaser of registered land should always be able to verify by simple examination of the register the exact nature of all interests existing in or over the land which he proposes to buy. Also, according to a journal article called Bringing Land Registration into the 21st Century, the Land Registration Act 2002 by Barbara Bogos, she mentioned how the LRA 2002 has reshaped the land law into something more transparent and clarified, and how it has reduced the disputes over property rights. So from both academician viewpoints, the LRA 2002 does provide you some adequate protection as a purchaser of a land. So there is another principle called the curtain principle that also protects your right. It means that the purchaser of the land should not be concerned about the matters behind the entry to the register. And there's also the insurance principle, which means that any flaw in the register leads to the payment of compensation to the person affected. So it ensures that purchasers are compensated and not left unprotected. Following to the next question that you asked is that, are there any interests that might override your title? Well, unfortunately, yes, because despite having these principles, not everything is perfect. The mirror principle cannot 100% guarantee that your rights are protected. Hence, we call it the crack in the mirror. It refers to the existence of proprietary entitlements that are not recorded in the land registry. So under section 11 sub 4 sub b of the LRA 2002, it states that the estate is vested in the proprietor subject only to the following interests affecting the estate at the time of the registration: unregistered interests which fall within any of the paragraphs of Schedule 1. So, when we take a look at Schedule 1 and 3, there are 7 kinds of unregistered interests that can override first registration. So first being leasehold estates and land, second is interest of persons in actual occupation, 3 is easements, 4 is customary and public rights, 5 is local land charges, 6 is mines and minerals, and the 7th is other miscellaneous interests. So for Schedule 1, it refers to unregistered lands, and 3 to registered ones. So because Pineview Cottage is a registered land, so we will focus on Schedule 3 now. So these rights are also known as overriding interests, and it can bind future purchases of the land. So because of the so-called crack, your rights are not fully protected, hence the overriding interest or interest that override, which we call ITOs. For now, we should focus on the interest that can override your rights, specifically given under Schedule 3 of the LRA 2002. It is also very important to note that registration is not required, and the doctrine of notice is irrelevant when it comes to these overriding interests. So this can be illustrated by the case of Williams and Glyn's Bank Limited and Boland, 1981. So in this case, the House of Lords ruled that a spouse's equitable interest in a matrimonial home along with actual occupation constitutes as overriding interest under section 70 sub 1 sub G of the LRA 1925. In this joint appeal, two wives had contributed a lot to their homes and had actual occupation of the lands when their husbands mortgaged the land without their consent. When the husbands had failed to meet their financial obligations, the bank sought possession of the houses, but the wives' interest took priority over the bank's registered legal mortgage. So that's when an overriding interest comes into play. So we will further discuss the overriding interest in the following scenarios concerning Tina and David. So now let's move on to the issue regarding Tina. First of all, for Tina, we have to know that whether Tina's lease is a legal one or an equitable one. So there's a difference between the two. So under section 52 and section 57 of the LPA 1925, if the lease is not created by a deed, the general rule is that the lease will be equitable in nature. You did not mention whether Tina has created a deed or not, so we are going to go with two scenarios. But before that, I would like to explain what a deed is. A deed is technically a signed legal document that transfers ownership of an asset from one party to another. Deeds are most commonly used to transfer ownership of property or vehicles between two parties. Basically, it's a written and signed document that transfers property to someone else without submitting it to the Land Registry. For the first scenario, if there is a deed, then the lease is legal even without registration, since Tina did mention that she has stayed there for 2 years and will be there for another 5 more years. To create a legal lease, according to section 54 sub 2 of the LPA 1925, if the lease is less than 3 years, it can be created informally, including orally, as long as it's the best rent. However, for leases more than 3 years, it must be created by deed to be legally valid. And as for leases for 7 years or more, it must be registered in accordance with section 27 of the LRA 2002. In Schedule 3, Paragraph 1 of the LRA 2002, it states that leasehold estate in a land granted for a term not exceeding 7 years from the date of the grant, meaning that leases less than 7 years will apply to this circumstance. On the other hand, if there's no deed, then the lease is an equitable lease. So now, if Tina has an equitable lease, we can refer to Schedule 3, Paragraph 2 of the LRA 2002. This section provides that the details of when an interest of a third party can override the property owner's interest, as well as we call it an overriding interest or interest that override ITO. ITOs in simple terms are those interests that are not registered but will still nevertheless bind the third party purchasers like you. It is what we call the crack in the mirror. We shall mainly focus on the following ITOs that we'll mention soon. First is whether the person has interest in the land, and secondly, the person has actual occupation, and thirdly, the occupation of the person will be obvious on a reasonable, careful inspection of the land at the time of the disposition. Let's look at the ITOs now and whether Tina has fulfilled or satisfied the criteria. Firstly, does Tina have proprietary interests? Well, yes. Tina does have proprietary interests. We have to refer to section 1 sub 3 of the LPA 1925. So no matter if it's legal or equitable, Tina's right is still binding over Alan. Was Tina in actual occupation? Obviously, yes, she was. She said that she's been living there for 2 years and will continue to live there for another 5 years, which accumulates to 7 years. So there is no mention that she has lived anywhere else but Pineview Cottage. So let's refer to some cases. So in Stockholm Finance Limited and Garden Holdings Incorporated 1995, the facts of the case are like this. So the owner is a Saudi princess and she owns a land in London. She had refurnished it, she had put her clothing there and had some caretaking arrangements there. But she and her mother had never lived there for a long-term period, but they only lived there when they visited London. So she claimed that the mortgagee had used the property without her consent, but it was held that the princess and her mother had no actual occupation as they had continued absence, so they both don't really have any overriding interest. However, in Koh Ker Xuan 1984, temporary absence does not negate actual occupation. So in this case, the husband sold the family home without informing his wife while she was temporarily in the hospital giving birth. The wife claimed an overriding interest in the property under her equitable interest and actual occupation. So the court held that her temporary absence does not negate her actual occupation, as she actually did intend to return to that property and her belongings were still in the house. Therefore, her interest took priority over the buyer's registered title. There's another case called Hodgson and Marks 1971. So those who are in actual occupation and had an overriding interest are protected under the section 70 sub 1 sub G of the LRA 1925. So the facts of the case are as so. Mrs. Hodgson, who transferred legal ownership of her house to a lodger while keeping equitable ownership, claimed her rights when the lodger sold the house to a purchaser. The court held that Mrs. Hodgson's equitable interest was protected as an overriding interest under section 70 sub 1 sub G of the LRA 1925 because she was in actual occupation and had not abandoned her rights. The purchaser was bound by her interest and had to transfer the property back to her. So according to these cases, Alan, you are bound by Tina's overriding interest. So lastly, was Tina's occupation discoverable? If the purchaser has tried to discover by reasonable inspection but still could not discover anything, it will be not binding. Since Tina has been living there for 2 years, it should have some obvious signs that somebody was occupying the place, so this could be on you, Alan. And we can say that you have not carried out your due diligence when inspecting the land as you should have. If you did, you would have noticed some signs that Tina was actually living there. So Alan, you should respect Tina's rights over the land. So let's move on to David's issue. According to section 27 of the LRA 2002, it says that the option to purchase a land must be registered at the Land Registry. This can be seen in the case of Howell Securities and Hughes 1974. The court held that an option was not validly exercised because the required written notice was not received by the grantor, emphasizing that courts enforce the formalities specified in such agreements. In this case, the defendant had given the plaintiff an option to purchase his house for £45,000. It was stated that this option was exercisable through a notice in writing within 6 months. The plaintiffs agreed to it and posted a letter, but the letter got lost. Since the defendant stated the option to purchase is enforceable by notice in writing, he would need to receive communication regarding the purchase to have a legal contract. Therefore, the option to purchase is not valid as it was not written and communicated to the seller. Another case to illustrate it is the case of Pritchard and Briggs 1980. In this case, Pritchard, the appellant, held a right of preemption, which is a right to be offered property before it could be sold to a third party, over land owned by Briggs, who is the respondent. So Briggs then sold the land to a third party without first offering it to Pritchard. The Court of Appeal held that a right of preemption does not constitute an equitable interest in land until the landowner decides to sell. The right remains merely a personal contractual right and does not bind subsequent registered purchasers. Therefore, the sale to the third party was valid and not subject to Pritchard's rights of preemption. Therefore, for David's option to be enforceable, he must prove that he has exercised the required procedures, like providing a written notice or registering it. If David can prove that he has done the formalities, then David's rights should be respected by Alan. However, if David fails to do so, Alan's rights are prioritized over David's. And as you have mentioned, you could not find any record of it at the Land Registry. Also, as seen in Pritchard's case, calling dibs on the land itself is also insufficient to bind subsequent registered purchases. So therefore, David's option to purchase is not binding over you. However, David may raise that he has an equitable interest in the land since he is Charles' brother. This may not work as it is not stated whether he has lived in the property or not, or whether if he has contributed to the property financially or equitably. This can be backed up with the case of Strand Securities and Caswell 1965. In this case, the court held that to claim an overriding interest, a person must have both an interest in land and be in actual occupation of the land. The stepdaughter, who lived on the property and kept their belongings there, had no interest in the land and was not occupying it as an agent, the subtenant. Therefore, neither she nor the subtenant could claim an overriding interest over the land. So now we can safely guarantee that David's claim to purchase the property will not affect your rights as the landowner now. Therefore, we can conclude your questions as follows. For your first question, yes, you are provided with adequate protection under the LRA 2002 as well as the 3 principles. However, not everything is 100% guaranteed, as we said, the crack in the mirror, which are the overriding interests. These overriding interests that Tina has may bind your rights as a purchaser. As for David, this option to purchase is not binding on you. So I hope that this helps you understand more about your rights now, and I hope that you can solve your issue soon.